In the prior segments, we've reviewed all kinds of topics involving the ownership of land. So, present estates, future interests, adverse possession, concurrent estates. And then we talked about the idea that you could possess land without owning it. The main area there is landlord-tenant law. Now, the next logical step is to talk about the right to use land, but not to actually possess it or own it. That's the area of non-possessory interests. What we're talking about here is things like easements, profits, licenses. That's what we'll review next. And, as I've said before, help us with the algorithm. If this is useful to you, then like the video, subscribe to the channel, turn the notification bell on if you want to know when the next segments are coming up. Okay, we're at item 6 on level 1, non-possessory interests, and there are 3 kinds: easements, licenses, and profits. Easements is by far the biggest subject. So let's talk about easements first. An easement is an interest in land. It's the right to enter land and to make limited use, or to restrict use. If you're making limited use, that's called an affirmative easement. If you're restricting use, that's a negative easement. How do we create an easement? There are several ways to create one. One is expressly, by grant. The grantor specifically conveys an easement. By reservation means that the grantor reserves an easement for his own benefit. So if, for instance, owner subdivides his land and sells off one piece of it and reserves the right to use that piece to go across and use a road across the piece that he sold, he's reserved an easement for his own benefit, and that would be an express easement by reservation. Now, notice that an easement is an interest in land, so the statute of frauds applies. Easements must be in writing. If there's no writing, then we don't have an easement. We have a license, and we'll come to that later. Another way to create an easement is by implication. A conveyance with some retention by the owner would be an easement by implication. For that, we need a common grantor. We need some sort of previous use. The easement must have been in existence before. It must be reasonably necessary for the dominant estate. And we need retention by the owner. And those are the elements you need to create an easement by implication.
So, and the dominant estate is the one that is benefited by the easement. The servient estate is the one that's burdened by the easement.
So whenever you get facts that go to an easement, one of the first things you need to think about is who's benefited, who's burdened, and define your terms. One of the ways you show your knowledge and understanding of the law is by defining all of these terms. So you can define the dominant estate, define the servient estate, and tell the reader, using your facts, who holds the dominant estate, who holds the servient estate, and why. Now, an easement by necessity is another way to create one. An easement by necessity means that there's a common grantor and the easement is really, truly necessary. And the courts are quite strict about interpreting what's necessary. And for an easement by necessity, the easement is good only as long as it's needed. So it must be continuous use in order to continue to exist.
So you can, the courts are going to be strict on this, because if you buy property and there's no easement, and now you're going to scream, but I need an easement, and go to court and try to get the court to give you an easement, why, they'll give you one if you could meet these very tough elements. But otherwise, you bought it, you should take what you get. You're trying to get more.
So, and Dennis just pointed out the difference between an easement by implication and an easement by necessity, one of the big differences. An easement by implication is one that's already there. It's already in existence. An easement by necessity is, as Dennis said, where the person who granted the land goes in and says, I need this easement. It doesn't exist, but now I need it.
Right, and by implication, you also have retention by the owner, and it's normally the owner that has the servient estate, and so it could be inferred or implied that the owner just simply forgot. And again, if you can meet the 4 elements Nancy gave you, then the owner can claim the easement.
And why would the grantor own the servient estate usually? Well, think about it. If someone is subdividing their land and selling off a piece of it, odds are they're selling off the more valuable piece of it. And they keep the less valuable piece, and they need the easement. We can also have an easement by prescription. And that's simply by operation of law. This is very much an adverse possession doctrine. It's by adverse use. So an easement by prescription means that an individual is openly using some part of the land exclusively, in other words, hostilely. The use is actual and the use is continuous. These are the same elements as our overall discussion of adverse possession. Now, there's one twist here. We said exclusive. Hostile means exclusive of the true owner and exclusive use. What about class easements? What about things like pathways to the beach here on the West Coast? Can we have an easement by prescription when more than one person is using that pathway? And yes, that's a class easement. And under a class easement, the use need not be exclusive. Now, what are the characteristics of easements? An easement appurtenant or appertenant is tied to the land. That means that you have 2 pieces of land and you have an intent to benefit the land. And we already defined dominant and servient estates. The dominant estate is the one that's benefited. The servient estate is the one who has some use curtailed. That's the burdened estate. So that's 2 pieces of land. That's an easement appertenant or appurtenant. What if there's only 1 piece of land and it benefits this easement, this right to use benefits a particular person? For example, the telephone company or the electric company. Now we have an easement in gross. So here's another set of terminology you can define. When you get your fact pattern, look at whether you have an easement appertenant or an easement in gross, and explain that to the reader and show the depth of your understanding. Now, what are the rights when we're talking about easements? The servient estate may not obstruct the dominant owner's right to use the easement. The dominant owner has the right to continue using that easement. Transfer of the servient estate subjects the new owner to the easement, unless, of course, it was sold to a bona fide purchaser without notice. And remember the 3 forms of notice: actual, constructive, and inquiry. Slightly different order than we heard before. Actual, inquiry, and constructive. So actual notice means you were told about it. Inquiry notice means you should have been able to see with a reasonable inspection. And constructive notice means it's in the deed. If the dominant estate is sold, on the other hand, the easement goes with it. It runs with the land. And the other right associated with easements is that the easement holder can go on to repair, even if there's no written right in the easement to do that. That's implied in the easement. The holder of the easement has to keep the easement in repair. That's one of the duties of the easement holder. And the easement holder also must make reasonable restoration of the servient estate. Now, what's the scope of the easement? Well, there can be express scope in writing. So, for instance, an owner can grant an easement to someone that is 30 feet wide and runs the length of the land in order to have a road. That might be an express grant of an easement. The other way to determine the scope is by prescription, and that means either the amount used or, as in our adverse possession discussion before, by color of title. And the final issue in easements is, how do we terminate an easement? Many ways to terminate an easement, and we list several of them for you. Its terms can specify when it's going to end, and so it can be terminated by its terms. We can give a written release and terminate the easement. Notice that simply not using the easement is not sufficient to terminate it. We need the intent to abandon the easement before it's going to terminate. What happens in the converse? What happens if someone uses an easement excessively? So say this owner granted a 30-foot wide road, path to get out to the road to a private property owner back behind him with mountains behind her, and she decides to open a bed and breakfast inn with a great restaurant in her home. And now 150 people a day are driving back and forth on that little road and destroying the peace and quiet of the homeowner who granted the easement. So we have excessive use. Will excessive use terminate the easement? No, it won't. For excessive use, that property owner's remedy is to get an injunction to stop the excessive use. It automatically does not terminate the easement. What will terminate an easement is sale to a bona fide purchaser without notice. Also, merger. If the person who holds the easement becomes the property owner, now by the doctrine of merger, the easement is extinguished. Estoppel is another doctrine that will terminate an easement. An oral statement or conduct that the easement will end, plus detrimental reliance. That will end an easement. And of course, by prescription, we already said that if an easement by prescription stops being used, the easement will end.
And you've already said a million times before, you can agree to anything, so
sure.
You can agree to terminate too. Okay, profits. Profits are the right to enter land and remove something. They are an interest in land, so they require a writing. They can be created by prescription. Their characteristics are identical to the discussion of easements that Nancy just gave you. However, there is a difference. Profits can be terminated by excessive use. So, for example, landowner may grant rock company or cement company the right to go onto the land and take away gravel. And now the concrete company gets greedy and just starts dragging everything off that property, excessive use, and that will terminate the profit. Finally, a license. A license is, in a sense, an oral easement, which is really a contradiction to terms because you can't have an oral easement. An easement is an interest in land, so requires a writing. So a license is where you give oral permission to another to go onto land. So say, well, it's okay for you to cross my land anytime you want, but that's oral. No writing, so no easement. These licenses are revocable at will unless the holder of the license has spent some money. That gives the holder of the license some detrimental reliance theory. So landowner says, you can go over my property anytime you want, and we see that the holder of the license now building a road while the landowner watches on. Well, now that you've spent the money, you now have an oral license, but become irrevocable because money has been spent, which is just about the same as an easement, with the exception that it will stay in existence until its purpose is terminated. Whereas if you actually have an easement, it's going to stay in existence unless you have one of the items that Nancy's already identified.
So keeping some of these distinctions in mind is a really, really good way to learn these doctrines in depth. So some of the distinctions we've talked about are that an easement may be created by implication. A profit may not. It requires a writing. An easement ordinarily requires a writing. It must meet the statute of frauds because it's an interest in land. But a license is, in essence, an equitable easement. An easement is not revocable at will, but a license is. So think about those distinctions. Give it some deep thought, and they'll be easier for you to remember.
Yeah, very good.